5 seconds to go. Start. In such circumstances, the argument canvassed on behalf of the respondent in regard to the applicability of sub-rule 3.3 of Rule 74 pales into insignificance. Stop. In other words, the argument that the Special Medical Board should not have been constituted pales into insignificance because the Special Board was constituted under the directions issued by the High Court. Stop. Para. Let us see what this court has to say in the case of Darga Ram alias Gunga Supra, upon which strong reliance has been placed on behalf of the learned counsel appearing for the respondent accused. Stop. In Darga Ram alias Gunga Supra, this court held as under, para, the medical opinion given by the duly constituted board comprising professors of anatomy, radio diagnosis and observation of itself, which is below, para. Directing an inquiry is not the same thing as declaring the accused to be a juvenile. Stop. The standard of proof required is different for both. Stop. In the former, the court simply records a prima facie conclusion. Stop. In the latter, the court makes a declaration on evidence, that it scrutinizes and accepts only if it is worthy of such acceptance. Stop. Para. In Rishipal Singh Supra, after due consideration of all its earlier decisions, this court held as below, para. What emerges on a cumulative consideration of the aforesaid catena of judgments is as follows, para. A claim of juvenility may be raised at any stage of a criminal proceeding, even after a final disposal of the case. Stop. A delay in raising the claim of juvenility cannot be a ground for rejection of such claim. Stop. It can also be raised for the first time before this court. Stop. Para. An application claiming juvenility could be made either before the court or the JJ board. Stop. Para. When the issue of juvenility arises before a court, it would be under subsection 2 and 3 of section 9 of the JJ Act, 2015. But when a person is brought before a committee or JJ board, section 94 of the JJ Act, 2015 applies. Stop. Para. If an application is filed before the court claiming juvenility, the provision of subsection 2 of section 94 of the JJ Act, 2015 would have to be applied or read along with subsection 2 of section 9 so as to seek evidence for the purpose of recording a finding stating the age of the person as nearly as may be. Stop. Para. When an application claiming juvenility is made under section 94 of the JJ Act, 2015 before the JJ board, when the matter regarding the alleged commission of offence is pending before a court, then the procedure contemplated under section 94 of the JJ Act, 2015 would apply. Stop. Under the said provision, if the JJ board has reasonable grounds for doubt regarding whether the person brought before it is a child or not, the board shall undertake the process of age determination by seeking evidence and the age recorded by the JJ board to be the age of the person so brought before it shall, for the purpose of the JJ Act, 2015, be deemed to be true age of that person. Stop.